I wish that we were at the zoo like we have been from many of you in the past. Um, I hope we get to do that soon. And until then, we'll talk about it in this same format that we've all gotten used to now in what feels like the 2,500 whatever Zoom meeting. But it reminded me as I was getting ready for this today that the last time we all talked about reopening was in this sort of format in Zoom setting was almost exactly a year ago on June 18th, 2020. And that was when we hosted a little coffee break called Preparing to Reopen. And I saw from the attendance list that some of you had attended that. So I couldn't help but go revisit, because who doesn't want to revisit 2020? And I was surprised looking back by how much things have changed and yet how similar some of the questions remain. So I thought, well, what has changed? The first thing that was very obvious to me is that we know more, right? That was 3 months into the pandemic, and now we have a vaccine. We know answers on whether we can require it. We have policies and procedures that we have found out work well for our people. We have routines. We have 2-minute commutes. We have home offices. We like ourselves. We know ourselves better, so we know what works for us. And we also have a light at the end of the tunnel. And these were all big question marks when we talked about this a year ago. But we still don't know a few things. We don't know, for example, how we will feel when we're asked to socialize again and when we're asked to be in the office again and resume a regular schedule again. And we don't know if we'll be able to recapture that sort of work rhythm or life rhythm even before the pandemic, or if we even want to. And we still have some questions about how all of our painstaking and thoughtful measures that we've been implementing throughout this year will work when it comes to practice once we bring our people in. So I thought for today, the best way to organize this is to talk about our strategy for reopening, but in the new lens of this new knowledge that we've gained over the last year and where we see it coming. So you'll recognize some of these topics: vaccination policies. It used to be mask policies, controls and safeguards, but we're thinking about them differently now. So we'll talk a little bit about what we've learned and how far we've come from a year ago. I'd like to start very briefly on vaccines and masks, and that's because my colleague Erin has an excellent presentation on them. I encourage you all to listen to it carefully. But for these big picture purposes, in terms of what, as you're preparing to reopen, with the vaccines, the first thing to keep in mind is that we now have guidance from OHA, OSHA, CDC, EOC, all these acronyms that says that employers have choices. Yes, we can require vaccines provided that we give accommodations. Yes, we can also ask for verification of vaccination status. And in fact, if we don't, we have to stick to masks and social distancing. And yes, we still have to keep this information confidential. But despite this, fairly clear guidance now, it seems that only about a quarter of employers have adopted a mandatory vaccine program, at least in my experience. The overwhelming majority of you fall in a spectrum between requiring it just for office presence versus not requiring it at all and maybe encouraging it or just not mentioning it. And the reasons for that seem to be several. Some of it is a management philosophy. Some of it is that you all know your workforce better and you know what will work. But there's also some legal risks and some considerations there. And Erin will talk more about it. But again, for purposes of reopening, as you're thinking of perhaps what policy you want to adopt or reduce in writing, there's a couple things I just wanted to highlight. The first question is a legal risk, right? Are mandatory programs going to hold out? Erin will talk more about that. In my opinion, I think they will. I don't think these cases or challenges that are against them, I think they're interesting. They're still unknowns, but I think at the end of the day, a mandatory vaccine program will hold out. The more interesting question for employers, particularly if you have workforces throughout the states, is are there going to be any barriers to any segments of your workforce to actually obtain a vaccine? We're seeing some concerns that some vaccination policies could end up having some disparate impact on protected demographics. So think about that. Again, we haven't seen that be a big issue in Oregon so far, but in some other states it could be. Another one is to be aware of some state privacy laws. If you've got employees in states outside of Oregon, some states will require you prior notice before you collect medical information. Again, nothing in Oregon like that. And then for a lot of you, the question has been one of employee morale. And that's going to be an overarching theme here for us, because in some ways, employee morale is kind of the biggest unknown, but also the beginning of kind of bringing back a workforce, because we don't have a workforce if we don't have workers. And one thing we've noticed over the last year is that this employee engagement, staying connected with our employees, has become not just a matter of legal compliance, but also a matter of recruiting and retention. And the reason for that is that often employees will say, you know, if I can go work across the street for an employer that allows me to work 2-3 days a week from home, I'm going to do that rather than the employer that requires me to work 9 to 5 again, because I can't handle that. So the first thing that you can do, and perhaps the most important thing to do, is to engage your employees early and periodically, particularly through this initial stage, if you haven't done that already. How do we do that? OSHA gave us some structure back in November when they unrolled their fairly extensive program about COVID in the workplace. And they said, you got to engage with your employees before you roll out what these COVID protocols are going to be. And so I recommend a similar process now, if you haven't done it, is to reach out to your employees in whatever means of communication you have established that feels most natural. The one that I would recommend is probably confidential surveys. It just allows employees to be a little bit more open about what their thoughts are. Focus groups are another good one, particularly if you can ensure a safe, non-judgmental space. But that would be the main place to start, and then continue to do it on a periodic basis, at least at the beginning. Other things we've learned over the last year is that some questions work better with employees than others. The main ones that you probably want to ask and seem to solicit a lot of information is how their experience has been working remotely, what has worked, what hasn't, what do they miss the most about being back so you can maximize it, what do they miss the least so you can figure out ways to fix that, and then what are their thoughts and input on reopening the workplace, things they might want to see, and things that they don't want to do. Now, employee engagement, as we said a year ago, still carries some risks, particularly if you're not doing it in a confidential, anonymous setting. So I would still highlight the fact that you need to keep an eye or ear out for protected sort of trigger points that you need to address. One is if they're sharing medical information and you know who it is, you're going to want to engage in the interactive process with the ADA. Some of them might hint at life circumstances that as an employer you might have to accommodate. Again, for example, domestic violence. Unfortunately, we've seen that rise during the pandemic, and some employees might need some protection. You want to be listening for discrimination and harassment, particularly ones that oversight in the office has been removed, because you want to be able to address that early. Again, a little harder and easier in some ways, depending on how you look at it, to do in a confidential survey, but keep an eye out for that as you're going through the employee engagement. And then once you do this sort of survey or turn the microphone to them, that's in some ways the easy part. The harder part is, what do you do with the answers? And you know, it's just like anything else. We study them and we try to learn from them so that we can retain the talent that we want to retain, particularly if they feel strongly about a phased approach, some kind of a hybrid approach of returning full-time versus part-time. And then everything that you would end up sort of collecting, you'd use to inform what policy and protocols you adopt for at least this initial reinstatement stage. And when we talk about a reinstatement program, I'm not referring to reinstatement in the way that we used to in terms of, or we do in terms of workers' comp or the ADA. I'm referring to it as simply just the sheer process of bringing employees back. And we said this a year ago, this rule still holds very true today, is as much as possible, treat employees equally and have a well-documented, legitimate, non-discriminatory reason for how you are implementing this program. For example, are you going to bring back certain positions first? Are you going to be able to bring back just managers and officers at the beginning? Or are you going to focus more on a schedule base, on employees that can satisfy certain regular office hours versus others that can't? Whatever that decision is, you are going to want to make sure that it is based on this neutral business-related reason. And no matter what, you're also going to have to treat some employees fairly, even if you can't treat them equally, because they will need their own unique accommodations. And the first one is high-risk employees. We've talked about them for quite a while, so we all know now who they are. And basically, in these high-risk employees, we're going to have a couple of categories. The first ones are the ones that have an underlying health condition themselves. They might not be able to get the vaccine. They might not be able to wear a mask. You likely continue to have to continue to accommodate them. Some of them may live with a high-risk individual, so even if they have had their vaccine, they still have to be careful about whether they go outside because they don't want to bring the virus back to a family member that cannot get the vaccine. The ADA wouldn't require an accommodation for you in that situation, but some leave laws might, including sick leave. And then you have older workers. Again, age itself doesn't require an accommodation, but when paired with an underlying health condition, it might. And then, of course, good faith, religious beliefs. All of those will need some equal fair treatment and accommodation, provided there's no undue hardship to you. Another thing about a reinstatement program is that once you come up with a plan and what it will look like, you're going to want to reduce it in a very clear policy, and you're going to want to train your managers. One thing that we have seen over the last year or so is that a good manager can save the company, and a non-trained manager or not skilled manager can risk sinking the ship. So you could have the most beautiful policy written with all the employee engagement you wanted, and if it's not getting implemented consistently, or if the managers aren't trained on it, you could basically be in just as bad a shape as if you didn't have a policy to begin with. So start training your managers, and then don't just train them on these new policies, but train them on existing policies that they probably haven't revisited in a year and that you might have to update. For example, the discrimination and harassment policies, which Chris Moorhead will talk about it later. And the reason I say that you're going to want a refresher training in addition to training for new policies is because over the last year, we have now started to see the first wave of pandemic-related litigation. So again, last year on June 18th, we kind of had some fears that we were thinking, some predictions about what kind of claims we'll end up seeing a year from now. And unfortunately, they've come true. A lot of those predictions and fears that we had in terms of what kind of litigation will arise have come to pass. And the first ones that we've seen just immediately right off the gate are the retaliation and whistleblowing claims. We're seeing a lot of activity there. And these claims are kind of interesting because these are the employees who back in March, April, May, June, that we were all talking about it, were saying things like, I don't want to come to work because I feel unsafe. Or, you're not finding enough masks for us. Or you're not enforcing social distancing with our customers. Those complainants have now become plaintiffs, as we suspected. And the question remains, what type of COVID-related complaint is a protected activity that gives rise to whistleblowing or retaliation claim? That is still a little bit unclear, right? Because these cases are all new. We haven't seen judges or juries rule on them yet. But we have seen very high activity on plaintiffs' sides in terms of asserting these claims. And if employees and employers are handling them sort of differently, some employees are settling at the beginning, not wanting to be a stress case, kind of a test case or a stress case. And some others are fighting them from the beginning because they want to avoid copycat claims, particularly if you had a layoff or a RIF. They want to send a strong message. It's an individualized decision you should make in close discussions with your counsel, but you should make early. Another type of claims that we've seen arise are discrimination and harassment, particularly along race, ethnicity, and national origin, and some political affiliation. And this is because, in addition to pandemic, our world has been going through reckoning in terms of racial justice and social justice reform. And so our employees are coming into the workplace very differently than they left a year ago. They're coming after the events of Atlanta. They're coming after the murder of George Floyd, and they have different expectations of their employers. It's no longer the case where you just get a typical harassment complaint of so-and-so made an inappropriate joke, and we use the formula, investigate, come up with a plan, conclude, implement. Employees are expecting more a year later. They're expecting employers to take positions and make a statement on various social events. Their complaints have changed in flavor, right? They've gone from your typical harassment to more implicit bias. And some of you know, we've talked about that for a while. They're wanting employers to be educated on social justice. They are expecting a seat at the table. They want ongoing trainings, and Parna can talk more about this later. But for your purposes is make sure you shore up your harassment and discrimination policies on the front end. There's been changes in Oregon law. Listen to Chris talk about that later. And be prepared. You know, I think you should budget for trainings coming up as you bring the workforce together, because employees are expecting more. ADA accommodations and leave laws, a huge wave of claims there as we expected, slightly different claims. It's harder now for employers to argue that you can't work from home. That's not a reasonable accommodation when a year later that's been the way of the world. We're also seeing a lot of a spike on wage and hour claims rising from employee lines in terms of waiting to be checked in, waiting to check vaccination status, you know, longer breaks for disinfection protocols. All of that is compensable time. So make sure that you have your timekeeping records and processes all in place. And then, of course, we've seen very increased OSHA activity. They have been very active during the last year. They just made their rules permanent. Megan will talk more about that. We can expect, certainly in the initial stage of reopening, that they will continue to remain active and find employees. One question that I get as we're talking about this, and I'm advising clients in reopening, is, well, Blerina, what can we do? What defenses have held up from what you told us a year ago? And the top three that have held up are the ones we predicted: is good documentation that can basically provide you an unassailable shield, and bad documentation can take a very good case into a very bad case. Have a legitimate non-discriminatory reason that's still holding up. You might have to litigate it, but the better documented it is, the better your chances. And then workers' compensation exclusivity, right? Back last year, there were some questions about how insurers were going to hold cases when the allegation was, you know, I got COVID at work. And now we know that likely the exclusivity provision will hold. So have your Form 801s ready and be prepared to hand them out freely. It helps you, it truly does. Defenses that we haven't seen pan out, that were all the rage a year ago, is liability shield laws. You might remember there was all this noise about whether states were going to pass immunity statutes for employers who were operating during the pandemic. Haven't seen that go anywhere in Oregon. Same with waivers. They were all the rage last June, particularly for customers. We cautioned against them then. I still caution against them now, not just because they're likely unenforceable in Oregon when it comes to employees, but also because of employee morale. They can be a real downer. And then there's this sort of different species of defenses, business necessity. This is coming up quite a bit in litigation. And it looks something like, I had to fire everybody because I did not know if I was going to survive. Or the opposite, I had to let these people go because they were refusing to come to work and I had to keep the doors open. Whether the business necessity defense will work is still unknown, but there is room for it in this pandemic litigation. So I encourage all of you to be open from the beginning with your counsel in case this is available to you. You'll see in this other slide some other considerations. I've listed them as a checklist. A lot of my partners and colleagues are going to talk more about that. For example, Haley will be talking about having a teleworking policy. The most important thing to keep in mind about this is to have a policy, right? Testing policy. Are you still going to require testing for employees who don't have a vaccine or can't get a vaccine? Same for symptom screening. One thing I did want to highlight here is performance evaluations. It seems like a small topic, but one that's coming up quite a bit. Over the last year, we have learned that positions that we have had in our workforce for 20 years, and we knew exactly what the essential functions were and the skills that were required for it, have changed. We have found that there's new skills that these positions require in a post-pandemic world, where there is a lot of working remotely and communications in these electronic forms. For example, fluency with technology is a good one, ability to capture time, ability to communicate with your client just as well via email as an in-person or lunch. Positions we've seen become obsolete, or at least on pause, event planning, and others that have arisen out of thin air, like Zoom experts. All of that, you're going to want to shore up your job descriptions, your performance evaluation forms, every form or process that you will use to assess or make employment decisions, discipline, termination. You want to make sure those are all up to date, particularly if you're going to engage in the interactive process and need an essential functions job list to be able to determine whether you'll provide an accommodation or not. Controls and safeguards, a lot of these will be familiar to you. Some of them come from OSHA, and Megan will talk about that right after me. The one I do want to highlight again here is security for medical information. We've been talking about this throughout. Most of you will know that any medical information you're collecting, whether that is vaccination status or COVID symptoms, is protected medical information. But employers are collecting it now in droves. We've never collected medical information more than we are today. And a year ago, it used to be where having this information under lock and key physically or password secured Excel spreadsheet that was only accessed by HR worked. A year later, that might not work. There will be more people in your workforce that will want to know vaccination status. For example, a manager might want to know before they send somebody on a work trip, or a receptionist that's at the door checking people in might need to know or end up knowing. So I would say work very closely on the front end with Privacy and Employment Council to come up with a process and to ensure you've got good security systems so that a year from now, we're not talking about a new wave of litigation for violations of ADA's very strict confidentiality provisions. You hear HIPAA come up a lot in this context. For a lot of you, HIPAA is actually not the biggest problem because a lot of you are not covered by HIPAA, at least in your employer functions. Some of you are. The biggest problem is the ADA's confidentiality provisions, which are extremely strict. So definitely don't let this fall through the cracks. Don't just assume that your pre-pandemic security system will work now that you have to share this information a little bit more broadly. And so a policy, or perhaps getting release, some permissions from the employees about who you can disclose this to, is good to do on the front end. And then the last, we'll end sort of the bookend to this is we started with employee engagement and we should end with employee support tools. And the reason for that is because the big question now still remains employee morale once the door opens, right? And it's important because, happy employees tend not to sue. Not always true, but in the majority of the cases, they don't sue. And employees who feel, about 90% of employment plaintiffs that have given answers to this say that they felt somewhat disrespectful, uncared for. So I think having this system, ongoing system on how to provide support initially at the beginning is going to pay off in the long run. We have seen now a year later that pandemic fatigue is real. We have medical authorities acknowledge it. We have seen that stress is real. We have seen that it has triggered underlying health conditions. It has exacerbated others. So having a system in place and employee assistance programs is going to be very important. Make sure you've got all that shored up, as well as a confidential hotline or some other safe method for employees to be able to report concerns, because you're going to want to know them too, again, on the front end. You know, I've put in here management training and documentation. And again, I cannot emphasize that enough. You've always heard us say document, document, document. Over the last year, we've seen the documentation become more important because people are communicating more in writing via emails, etc., etc. So make sure that you're teaching employers and trainers and your managers not just how to apply policy, but how to write. You know, what's acceptable to say via text and what still requires an email. COVID-19 committees, continue to keep a COVID-19 workforce, continue to stay abreast of these changes, because another thing we've learned over the last year is that things change very fast. And even though things seem stable now and we're all optimistic and hopeful, don't just assume the rules will stay stagnant. They're changing every day. So keep staying alert to the agency announcements, keep Googling, keep talking to your HR folks, to your employment counsel, and make sure that you are not falling behind as this progresses. Thank you for your time.